All right, I am live. This is for a bit of a spontaneous video, but once again, somebody asked the question, well, what happens if they break an open source license? What happens if they don't agree to the terms of the open source license? I have personally answered this question a lot of times on Reddit and other social medias, and um, and it just keeps coming up. And the number of bad answers, there's so many bad answers out there. So I thought let's just give you the right answer. So who am I? I'm Matthew Newsom. I'm an attorney. I am a copyright and intellectual property lawyer. I'm also a small business lawyer, and I love working with technology companies and startups to help them grow their business. And and because of my technology background, a lot of people trust me when it comes to software and such. So, I'm constantly looking at code, doing analysis, helping people buy or sell businesses or other assets that relates to copyright and source code. And one of the coolest things about the technology world is this concept of open source licenses. And so let me just first of all explain what we mean by a license and open source. And then just a moment, I'll tell you the answer to the question about what happens if somebody breaks the rule. And first of all, I'm at my home office. There's my purple wall. My cat is sitting on my lap. And so you might see some interruptions here, but we can still give you a good answer. The So first of all, let's just talk a little bit about what copyright means. When you create something, if you sing a song, if you record a video, if you write a book or a poem, or if you produce computer source code, then you get copyright over that material. The exception might be is if you're working for an employer, then in that case, your employer would probably have the copyright over that material. But for the thing that's important here is that because this is computer source code or whatever that programmers write, then it does have a copyright. And that means that the person who creates it and owns that copyright, they get to choose what other people do with that software. They get to choose. Do people have the right to copy it? Do they have the right to change it? Do they have the right to, share with others, publicly display it, things of that nature? And so, as the copyright holder, you get to have a say. Now, sometimes we write software with no intention of ever sharing it, right? So, I have on my computer some little automations that I've created that, that are not going to be really useful or interesting to anyone else. And a lot of people have toyed around, and so they just don't care. But a lot of times when professionals write computer source code or computer software, their intent is to share it with people, distribute it. It might be something that they're going to use commercially, maybe on their website so that they can operate a business, or maybe they're going to sell their source code. But another thing that people often do is they share it freely so that other people can gain some benefit from it. And when you share something freely, you usually do so with some rules attached to it. And so that's where this open source idea and that's where the idea of a license comes in. So let me just dig into this. So if you write computer source code, or maybe you don't, but you know a lot of people who do, all right, it is very rare nowadays that a person writes an entire program from scratch. Usually, new modern day programs are developed with significant amounts of other people or third party code incorporated into it. So, for example, if you wrote the simplest possible iPhone or Android app, you would be using a lot of source code created by Apple or Google, and that is included into your app. So you might only write 25 lines of code, but in total, there might be 500,000 lines of code total because you're using third-party code that other people have allowed you to use. And that third-party code was lent to you, not given to you, but lent to you with an agreement that there are some things you're allowed to do and some things you're not allowed to do. And the most common thing that you'll see as a limitation is you're not allowed to claim it as your own, right? You're just permitted to use it for now. And that way, if you ever decide to, use it for some terrorist activity, they can say, we're taking the code back. You can't have it anymore. But generally speaking, you're allowed to use it. Uh, The world has benefited greatly from this idea of people creating code and sharing it with others, and it allows us to create things faster and better. Because, for example, right here on the screen, you see my name overlaid on the corner of the video. And so somebody created code that makes it easy. And so this company that makes the streaming software, they didn't have to do that from scratch. They used this borrowed code. Okay. So when you create code that you want to share with others, you do so by giving a contract to them, and that contract will include language on what is allowed and not allowed. And when we're talking about open source code, what you're talking about is the open source definition. And I've got a little screen here that I can share. So not that one. Here we go. So this is a list of some of the common open source licenses that are out there. These licenses basically say that you, the author of the code, the copyright holder, give to other people permission to use the code as long as they follow these rules. And in order to be open source, one of the rules is you can use it for any purpose. You can use it for commercial purposes. You can use it for educational purposes. You can use it as a hobby, but you don't care what they use it for. If you say you can only use it for non-commercial purposes, that's fine. That is a valid license, but it's not an open source license. Open source means you can use it for any purpose, but here are the rules. And each of these different licenses, some of these are more popular than others, have different rules. And so you see here, there is an MIT license. The MIT license is an extremely popular open source license. And one of the reasons why it's so popular is because it is very simple. It essentially says you have to just give me credit for using my work in your product. Okay, that's pretty easy. And you don't get a warranty or guarantee of any kind. And so if it breaks your program, tough luck. And most people are comfortable with that, but it's a very, very simple thing to understand and read. Another one that's very, very simple to read are some of the older BSD licenses here. Again, very short, simple language, and they don't put very many demands on people who want to use it. So that makes them very, very popular. And I'm not trying to give you a survey of every license, but I do want to just talk about a couple important ones. The Apache license is another incredibly important and popular license. The Apache license is so popular because it is very friendly to people who want to use the open source software for commercial purposes. It is a longer license. It is a little bit more complicated, but it also is very clear on what you get and don't get. And that does make people a little bit more comfortable and confident. And again, it's very easy to comply with. And so the Apache license is a very popular one. And then there's two more that I want to talk about. One is the GNU General Public License, and there's two. There's a version 2 and a version 3. Both are extremely important, popular licenses. The internet is built on the back of software that is released under the GNU General Public License family of licenses. It's extremely important. And so if you are familiar with this term called Linux, Linux is composed of software that is released to the public under a GNU General Public License. The GPL, which is what we call it, is a copyleft license. And what that means is that it puts a requirement that if you want to use it in your code and then distribute your code to other people, then your code must be distributed under the same license. And so if I create a program and I include the GPL or the GNU GPL 2.0 or 3.0 license, and I share my code with other people, then my code must also be released under that same GPL 2 or GPL 3 license. Okay, it's very important. And so if I make a new driver file for a new kind of web camera or new kind of computer mouse, and I include that license in the Linux source code, then I have to make that license of that software available under the GPL license, just like the rest of Linux. That's a requirement. And so this is something that people will sometimes fail to do, is they will use open source GPL licensed software, but then they will not release it under an open source GPL license. And so that would be breaking the terms of the license. And so they would be breaching it. That's a very common, very clear example. And then I want to just show you one more license that is very similar, and it's the GNU Affero General Public License. And so it is called the AGPL license. And the AGPL license is also a copyleft license, but it is even more so than the GPL, because the GPL copyleft provision is that when you distribute the source code that you've made to others, then your components at that point must be licensed under the GPL. But there's a lot of debate on the internet on what it means to distribute. And so do you use it internally inside your company? Is that distribution? The general consensus is not, but that's not legal advice. Talk to me if you want to know if that counts in your situation. But that is a common interpretation. The AGPL license clarifies this a little bit more, and it says if you do not distribute your code, but you make the service built with AGPL licensed available to other people, even on a network, then now your software is subject to the terms of the AGPL license. So what that means is if I create a website using software that is GPL licensed and I host it on my own server, that's not a distribution. So it doesn't trigger the GPL's copyleft provision, but it would trigger the AGPL's copyleft provision because I would make that service available on the network. And so if other people can access it, then I have to share the source code of my website or my application with other people under the terms of the AGPL license. For that reason, some companies are very hesitant to use software that has the AGPL license on it, and to some extent the GPL license, but especially the AGPL license, because they just don't want to accidentally slip up and be required to disclose maybe confidential information to this software and have it be released under an AGPL license. Okay, so these are examples of the terms. So what we talked about is a lot of licenses like the MIT, the BSD, and the Apache license essentially say you must comply by giving credit where credit is due and not requiring a warranty. The GPL license family is a copyleft provision. If you distribute it, then you must make your software available under the same license. And then the AGPL license, the copyleft provision is if you make it available on a network, then you must distribute your code under an AGPL license as well. Okay, so let's just say that you created a product and you weren't aware that you were using AGPL code, and someone says, "Hey, it looks like you're using AGPL code." This, by the way, happened to Donald Trump. He created his Truth Network. The first version of it was built on software that was AGPL licensed. I think it was Mastodon, and so people said, "Oh, hey, Donald Trump is using Mastodon, so any code that Truth Social Network made needs to be released under the AGPL license." And I don't exactly know what happened there, but that was a valid statement. Okay, and so this happens. People use AGPL code all of the time. So what happens if they refuse to release the source code that they developed under the license in a way that's compliant with it? Okay, so this is what happens is now the person who is using the third-party code has broken the terms of the license. They've breached the license. And let me just pull up an example of what the license looks like. Oh, go. So here's what the license text looks like. This is one of the simplest open source licenses. This is the MIT. Copyright year 2024. Copyright holder. That would be your name or your company name. Permission is hereby granted free of charge to any person obtaining a copy of the software and the associated documentation files to deal in the software without restriction. Okay, therefore there's the open source clause, including without limitation the rights to use, copy, modify, merge, publish, distribute, sublicense, and or sell copies of the software and to permit persons to whom the software is furnished to do so, subject to the following conditions. Okay, and so this is the thing. They don't care what you do with it. You can even sell it. Okay. Here's the rule, though. You must follow this one simple rule. The above copyright notice and this permission notice shall be included in all copies or substantial portions of the software. And then here's the little disclaimer that goes with it. This software is provided as is without any warranty. I won't read the rest of it, okay? But you see here, this is a very easy rule to comply with. Let me see if I can show you an example of how people do this. So if I click on About Google Chrome, then you'll see that Google Chrome is copyright 2024 Google LLC, and it was made possible by using open source project and other open source software. And so we click here and we see that, look, they've used some software that uses an open source license that requires that copyright notice there. Okay. And so I don't know what some of these things are. I don't know what most of them are, but CRC 32, here's the license. Okay. So this is not the same license that we just read, but it says they're permitted as long as the following conditions are met. Redistributions of the source code must retain the above copyright notice and the following disclaimer. And then if the distribution is in binary, then it must reproduce it. So look here, they have complied with this license. Good job, Google. That's not that hard to do. Okay, well, what if they don't? Then the person who owns the copyright has the right to revoke the license. And so I'll come back to that in a second and I'll dig into it. But look, this does happen. You don't see it happen too often, but a year ago, this company, I don't know who they are, but there's a company called Mini.io, and they use kind of a hybrid model where they have two versions of their software, and one is open source that anybody can use as long as they're okay with the open source license, and then they have another one that you can pay for. And so you can choose, if you don't like the open source version because you don't want to follow the agreement, then you have plan B. You can just pay for it. And so the license that Mini.io software use is the Apache license 2 or the AGPL version 3. And so this company here did not follow the rules, and they did not comply with the requirements of either of these licenses when they did it. And you can read up all about this on your own. And so because of that, then Mini.io did what they are allowed to do. They revoked the license. They said, you no longer have permission to use the Mini.io software in your software. And so that means now this company, Weka, I'm not sure how to say it, is now using unlicensed third-party software. That would be like you going to Napster or BitTorrent and downloading a Warner Brothers movie and watching it without paying for it. Okay, you're supposed to pay for it or use a streaming service and use it in a licensed way. But if you use a pirated copy or whatever, then it's unlicensed, and that's not allowed. That's not fair. You're violating federal and international copyright law by doing that. So if Weka continued to use Mini.io in their product, then Mini.io would have reasonable grounds to take them to court and sue them for using copyrighted software without permission. That's absolutely within Mini.io's rights. So let me just talk a little bit about these licenses. So the license, the copyright holder has a right to control what people do with their software. And they said, if you do this, okay, here's the rule. If you do this, then you can do this. And then if you don't do this, you do not have the permission to do this here. And so you don't have the permission to use, copy, modify, merge, publish, distribute, sublicense. And this language is right from US copyright code. So that is that's pretty much just literally the language in the US code for copyright. This is a contract. An open source license and any software license is a contract. In fact, a more appropriate name is that it is a license agreement. And anytime you see a piece of paper or writing that has the word agreement on the end, then just know you're probably talking about a contract, because a contract is a legally enforceable promise or an agreement. I'm going to do this, you're going to do that. We agree. Okay, we have a contract. That's what's going on here. In this case, we are talking about a special kind of contract called a unilateral contract. I'll let you do this as long as you do this. And we don't have to go have a handshake. We don't have to sign papers. We don't have to do anything like this. I just set it out there. If you want to do it, then all you have to do is follow this rule. If you don't follow the rule, then we don't have a contract, and you're using it without permission. And so this example here, Weka, they breached the contract. And so they said, okay, contract's done. You don't have a right to use it anymore. And a lot of people don't realize that an open source license agreement is just a contract. And if you breach the terms of the contract, then you no longer have an agreement. You no longer have permission to use software. You are now violating copyright. Copyright law is a big deal in the US and the world. Most of the countries in the world have entered into treaties with each other to enforce copyright laws across borders. There's very, very few exclusions of countries that don't follow the treaties for copyright law. And so wherever you're at in the world, somebody can probably file a suit against you for copyright infringement. And if you're in one of those countries that doesn't have it, you probably know, because copyright violations are probably rampant. So obey the open source licenses. A lot of people, they don't know what they're doing. They don't know what open source software they're using, and therefore they very commonly break the terms of the license and use it in inappropriate ways. It's very common. In most cases, the copyright holders like Mini.io, they do nothing because it's not worth it. And they're usually just happy that more people are using this software because they want to give back to the world. And it bothers them, when people use it inappropriately, but not that much. But sometimes you see companies, and I think that this was one of them, they're making money and profiting from other people and not giving back in a way that's appropriate. And so they did what they're allowed to do. All right. If you have questions about open source software, I would love to talk to you about it. I help companies all the time stay compliant. For example, when we see companies that are being acquired, then oftentimes there needs to be an audit of the software to make sure that they're compliant with the open source licenses. I can help you with that. And so I would work with your technical team, or in case you don't have a technical team, I can sometimes fill in, but usually we'll work with your technical team and we'll do an audit of your software and let you know that there's problems or that you're safe. And that way you can go into your negotiations with a good understanding of what your position is. And so you can reach out to me here on whatever social network you like, or you can go to surge.law and you can fill out my contact form or book an appointment with me right there. I'm Matt Newsom. I am an attorney. I do caution you about taking legal advice from the internet because everyone's situation is a little bit different. If you have questions that are very unique and very personal, reach out to me and I can give you individual legal advice specific for your situation that'll give you good answers. Until then, we'll see you again.